Our next case is Christie versus Wayne State. This is a 15-minute mini oral argument on the application. Welcome, counsel. You may reserve some of your time if we do not use it up, and we ask you to do your best to keep track of that yourself. And you have 2 minutes of a free fire zone if you wish.
Thank you, Your Honor. I would like to reserve 1.5 minutes of my time for rebuttal, please. May it please the court, Daniel Tukel, representing appellant Wayne State University. The primary question in this case is whether the notice requirement in Section 6431 of the Court of Claims Act applies to statutory discrimination claims against a state entity which, because there's been a jury demand, are permissibly filed in circuit court. In its filings, the university has laid out in detail its arguments as to why the rules of statutory construction dictate that the notice requirement is not limited to claims that are pending in the Court of Claims, but apply equally to cases permissibly filed in circuit court. The appellate courts, including this court, have repeatedly stated that the notice provision is unambiguous and clear. The primary argument we have made regarding statutory construction is that because the statutory language is clear and unambiguous, it must be strictly construed and applied as written. And I'm happy to answer questions about that, but I would like to spend some of my time addressing the policy considerations underlying the notice requirement. This court in the McCahan case stated that the notice requirements, like that in Section 6431, serve a number of important policy functions. Notice provides the state an opportunity to investigate and evaluate claims. Notice allows the state to reduce the uncertainty of future demands. Notice puts claimants to an early choice regarding how to proceed, and it ensures that the correct government entity will receive notice. Most cases that are filed against the state or state instrumentality such as the university have exclusive jurisdiction in the Court of Claims. There's concurrent jurisdiction in circuit court for statutory discrimination claims against the state in only a narrow range of cases. Concurrent jurisdiction applies only if the plaintiff is seeking money damages alone and not equitable relief, and only if she demands a jury. There is nothing in the statutory text or in this court's prior decisions regarding the notice requirements that suggests that the policy considerations underlying the notice provision do not apply equally in cases filed in circuit court. And a consideration of those policy concerns shows that they do in fact apply equally, if not more so, when there's a statutory civil rights claim permissibly filed in circuit court. For example, the first policy factor articulated by this court in McCahan is the opportunity to investigate and evaluate claims. If the notice requirement does not apply to statutory discrimination cases filed in circuit court, the university or the state may have no knowledge at all about the potential claim until 3 years has elapsed. At that point, clearly it's much more difficult to investigate claims. Witnesses may be gone, memories certainly will have faded, records such as emails or text messages may very well have been deleted, but there is no dispute that the identical claim involving the same parties, the same facts, the same causes of action that is filed in the Court of Claims would require notice within 1 year. Another policy consideration articulated by the court is assisting the state in reducing the uncertainty of future claims, and certainly the level of uncertainty that attaches to a case that will have a jury sitting as finder of fact is at least as great, if not greater, than when the court is sitting as a finder of fact. Yet the position...
Counsel, good afternoon, and you're doing an excellent job. I just have to engage because you're focusing on public policy, and so which is completely fine. So I just have to. I can't resist the urge to engage you on public policy, since that's the primary focus that you're kind of putting forth today. And I guess the question I'm going to kind of pose to you is, under your public policy argument that you're putting forth as it pertains to notice, is really your entire argument under the public policy threshold that you're putting forth to the court today that this is just a huge hindrance and a tremendous burden for an institution like Wayne State, which is valued at $1.5 billion, that has an annual operating budget of $500 million. Your argument from a public policy perspective is that this is just a tremendous burden, a tremendous challenge, and a tremendous hardship to put upon an institution of the size and nature and scope of Wayne State. Is that kind of the essence of your argument?
I'm not sure what burden exactly you're referring to.
Well, you were the one that was indicating that, like, the notice is critical because it allows for them to investigate, it allows for them to do all these types of things. So what I'm saying to you is that under your public policy argument, if this court were to ultimately hold that that the notice requirement is not applicable at the state trial court level, your argument, I just want to understand, is your argument that this is going to put a hardship upon the institution? I'm just trying to understand, you've put forth public policy arguments, and I'm just trying to understand, trying to size this all up, what is the overall implication to the institution? What is that, your contention?
Well, two things, Your Honor. First of all, I am not arguing that the public policy is what should drive here. This court has said that the public policy underlies the notice requirement.
No, I understand,
My argument is
but
that those policies apply equally.
No, I understand, and I totally appreciate that, and you're doing a great job. I totally get it in terms of the argument that you're putting forth based on the court. But I guess I'm going to turn it back to you by asking you, folding this all together, what is the main concern from your public policy perspective that you have as it pertains to the impact it's going to have on the institution?
Well, certainly with regard to the ability to investigate claims. With the number of employees that Wayne State has, as well as the state itself and other state institutions that would be subject to this, they have many employees. They don't routinely investigate the circumstances every time an employee leaves or is terminated. When they have notice of a potential claim, they certainly have a basis for doing an investigation, and that the ability to do that investigation is greatly hindered if they have no notice until 3 years after the event.
I see.
Because of the loss of witnesses, the loss of memory, the loss of records, and that policy applies equally, if not more so, when it's a statutory discrimination claim in circuit court than it would for the identical claim filed in the Court of Claims, but with no jury demand.
Counsel, how much of this, I'm just curious of your opinion, how much of this is an issue because of the fact that the Court of Claims Act now moves the Court of Claims to the Court of Appeals? That prior to, right, it was Ingham Circuit, you file in Ingham Circuit, any notices are being, the Court of Claims is the entity in which the lawsuit has been filed. You get your jury demand if you demand it, or if it's the right type of claim. This sort of, I mean, there's no doubt that a plaintiff, I'm not sure why they would file in the Court of Claims in this type of case, because I would think that they would want a jury trial, but they can. They could file a PWDCRA or an ELCRA claim in either the Court of Claims or the Circuit Court. Is it an issue that, you're filing in Circuit Court, but you have to file notice in a whole different court, really sort of like the statute didn't clear up the fact that now we've moved it from the Circuit Court to the Court of Appeals? Well,
I don't think that the fact that the Court of Claims is now part of the Court of Appeals changes the issue. And I think that the legislature did clean up where the notice has to be filed, particularly because the case now can proceed not only in the Court of Claims, but in the Circuit Court. And we've identified a number of portions of the Court of Claims Act where the legislature was very specific about where something had to be done and identified the clerk of the Court of Claims when it was a claim that was limited to something that could be brought in the Court of Claims. The legislature did not do that in the notice provision. It simply says a claim cannot be maintained against the state unless the notice is filed. The Court of Claims Act has been amended a number of times. One of the biggest amendments, obviously, was moving the Court of Claims to the Court of Appeals. And when that happened, in that amendment, there was no change whatsoever to the broad language of the notice requirement. It didn't change it one word. Then when there was a short time after that, there was a question about whether jury trials had now been eliminated for example, statutory discrimination claims. The act was again amended, saying that nothing in the act reduced the right to a trial if one had been provided before by law, and that in such a case, the case could proceed in the circuit court or the probate court or the district court, whatever was appropriate. But even though it did that, and clearly at the time it made that amendment preserving jury trials, the legislature knew that some of these cases would in fact be filed in circuit court because it explicitly now said so. It didn't change the notice requirement. The language of the notice requirement was still left just as broad as it ever was, saying it had to apply to, that no claim could be maintained against the state unless notice was filed. It would
So
have
the
been a
Court of Appeals is just in this case where it's, or in these cases where you're, the actual claim, the actual complaint and the litigation is proceeding in circuit court. It gets a case number there. It's got a docket. It's proceeding that way. The Court of Appeals, though, is just the depository for this notice
Yes.
for a case that it doesn't have.
That's correct, because one of the policies that this court has indicated underlies the notice provision is that the appropriate state entity receive notice, and establishing a central repository for notices in the Court of Claims assures that that happens. That notices aren't filed in multiple different courts. There's one place that it goes. That court clerk can then notify the appropriate state entity, and the case can proceed in the circuit court if that's the place that it's been filed.
Counsel, what do we do with the fact that under the Government Tort Liability Act, there's an express provision that the Court of Claims notice process has to be followed, and obviously under Elliott Larson and Persons with Disabilities Civil Rights Act, it doesn't contain that same language?
Well, I think what the Governmental Tort Immunity Statute says is that it has its own notice requirement in it. And the statute says that that notice requirement satisfies the Court of Claims notice requirement. So if anything, I think that suggests that the Court of Claims notice requirement would otherwise apply, but that the specific requirements that are engrafted into that statute satisfies that. The argument that in every statute where there's some jurisdiction in a court other than the Court of Claims, there also has to be added language saying that, oh, and you still have to file the notice, I think is not the way that statutory interpretation is normally done. This court has said the legislature legislates by legislating, not by being silent. And by being silent in Elliott Larson, but leaving the language intact in the Court of Claims notice provision, saying a claim cannot be maintained against the state unless the notice is filed, I think the legislature has done everything that it needs to do to make clear that this applies broadly, regardless of the type of claim and regardless of the court in which it is filed. Interestingly, Ms. Christie has never made an argument that the policies that this court says underlie the notice requirement don't apply equally in a circuit court case, and clearly they do. It doesn't make any sense, in my view, that and there's nothing in this court, in the statutory text or in this court's decisions that suggests that it was the intent of the legislature that the state should have less notice in a less timely manner when the identical claim is filed in circuit court than when it's filed in the Court of Claims. The legislature has balanced in the statute the benefits to the state in requiring timely notice against the procedural requirements it places on a plaintiff. That determination of the proper balance is a legislative function which is clearly and unambiguously articulated in the statute itself and should be enforced as written. I think it's important to note what may happen if that isn't the case. It allows for, first of all, there would be certainly confusion and a lack of clarity in certain circumstances, but it also allows the possibility of gamesmanship. For example, if a matter is filed in the circuit court and notice is required but not filed, the defendant could simply raise lack of jurisdiction as an affirmative defense, wait for the 1 year to pass, then move to dismiss for lack of jurisdiction, and at that point, the plaintiff will be time barred from refiling in the Court of Claims and would be completely denied their cause of action. It also might provide the opportunity for gamesmanship by the plaintiff. For example, if the year has already passed and the plaintiff has a case that essentially is a breach of contract claim, they might choose to try to characterize that as a statutory discrimination claim of some sort, thereby being allowed to file it in the circuit court and have no obligation to follow the notice requirements. And none of these issues, uncertainties, or opportunities for gamesmanship arise if the notice requirement applies to cases that are filed in circuit court.
I just want to clarify. So the statute requires a notice of intent to file a claim or the claim itself.
Right.
So if the plaintiff, I think as frequently happens, or at least I've seen it happen, is that they file the complaint rather than the notice, right? The complaint, as long as it meets all the other requirements, satisfies the statute. The defendant being served gets that same notice, right? I mean, gets the complaint. So if you're not doing a pre-suit or a notice of intent to file a claim, what does it matter whether you got that claim because you're a defendant in the circuit court as opposed to filing a second copy of the complaint with the Court of Claims?
Well, for one thing, the statute says that the notice has to be filed, either the notice or a verified complaint needs to be filed with the clerk of the Court of Claims. So if a verified complaint is filed within 1 year in the Court of Claims, no other notice is required. But since the statute says that either the complaint or notice has to be filed in the Court of Claims, filing a complaint in circuit court does not satisfy that. And in the McCann case, this court was faced with a situation where the university had actual notice of the claim. There had been ongoing settlement discussions for a period of time, but the notice hadn't been filed. And this court said, you need to file the notice. It's got to be strictly construed. That's what the statute says. And if you haven't done that, actual notice is not sufficient, and nor can you engraft a prejudice element that doesn't exist in the statutory language itself. And I'd also just like to briefly point out that there's also a jurisdictional issue here. I think it's been briefed fully, but the Court of Appeals said that because governmental immunity was not implicated by the Court of Claims Act, there was no denial of governmental immunity and therefore no jurisdiction for an appeal of right. But clearly, the university asserted governmental immunity. In fact, this court said in its order requiring supplemental briefing that the defendant filed a motion for summary disposition asserting governmental immunity. So the plaintiff agrees, the defendant agrees, this court agrees that governmental immunity was asserted. Clearly, when the trial court denied summary disposition, it was denying an assertion of governmental immunity.
Does it have to be an arguable claim of immunity?
An arguable claim of immunity, yes, but if...
I mean, like, if a private defendant said, I'm filing a motion for government to dismiss based on governmental immunity, clearly not entitled to it, they're not a governmental party. If the court denies it because it's clearly wrong, is that a denial is that a final order appealable of right because they asserted governmental immunity?
Well, it wouldn't be an assertion of governmental immunity by a governmental entity. So I would say in that case, the answer would be no. But the Court of Appeals conflated the merits of the argument with the assertion of the argument. And if the merits of the argument are what governs, and the trial court has determined that there was not, in fact, governmental immunity, and therefore it wasn't a denial, and therefore it's not immediately appealable, it essentially renders a denial of immunity unappealable, because immunity has two factors. One is immunity from liability, but the other factor is immunity from needing to go to trial itself. And once that's denied, if it can't be appealed to the Court of Appeals, the case goes on, it's litigated, and the factor of immunity from the trial itself is essentially lost, because it can't be raised until after the trial has been conducted, or an application for leave filed, which is discretionary of the Court of Appeals to accept or not. And I think that's why those types of orders are immediately appealable, is to make sure the state doesn't have to undergo the burden of a trial when there is, in fact, immunity, or at least an assertion of immunity.
Thank you.
Good afternoon. May it please the court, Jennifer Lord on behalf of the plaintiff appellee, Susan Christie. I'd like to reframe the discussion about policy considerations and direct our focus to the purpose of the Elliott-Larsen Civil Rights Act and the Persons with Disabilities Civil Rights Act. Those statutes are remedial in nature, and courts are encouraged to interpret them as broadly as possible so that victims of discrimination in the workplace have access to a remedy. And what the defendant appellant is proposing in this case denies access to victims of discrimination. The circuit court has the legislature has prescribed that venue is proper in the circuit court. There are no other steps that plaintiffs have to go through to have a discrimination claim in circuit court. This court should reject the attempt to block access to victims of discrimination from obtaining justice under these important civil rights statutes. Now, I think that the defendant's argument is based on a false premise. And the false premise is that there's only one way to waive immunity. And they point to the Court of Claims and say, you can get out from under immunity if you follow these conditions. If you file this notice in another part of the Act, if you verify your complaint, there's different conditions. And we do not quibble with the fact that the legislature can obviously place conditions on waiver of immunity. But here, we have statutes that have expressly abrogated immunity. We have Elliott-Larsen, Persons with Disabilities, similarly, the Whistleblower Protection Act. Those are all statutes that strip the question of immunity away. The question of immunity is not there. And as this court pointed out in Progress 2, another way to look at it, to kind of simplify, are we really inquiring into immunity or not, is immunity a defense to the claim? And in Progress 2, the court had before it a claim, a FOIA claim. And the court said, immunity is not a defense, immunity doesn't apply, end of story. So to simplify things, as Justice Bernstein recommended, the linchpin to resolving both of the issues before this court is to decide whether or not the state had immunity under the Elliott-Larsen Civil Rights Act. If it does, the denial of the defendant's motion for summary disposition was a final order, and it was appealable as of right. If it does, all the plaintiff had to do was file a notice of intent in circuit court as a condition of the state waiving that immunity. It's that simple. Now, we know that the state fully abrogated immunity in both of the statutes because the legislature defined the state as an employer. A little bit different ways in Elliott-Larsen, expressly included in the definition. In the Persons with Disabilities Civil Rights Act, an employer is defined as a person who employs one or more individuals, and then the state is scooped in. But it's just as simple as that. There's no immunity, there's nothing to condition the waiver on. Now, another element of this is whether the notice provision is procedural, whether or not it is the rules of the venue, the forum that you're going to be in. And I'd like to point to a few areas of authority to show that this Court of Claims notice provision truly is procedural and procedural only. First, this court in McCann defined it as such, said notice provision is procedural. That's pretty compelling. Also, with its placement in the Act, and the Tyrell Court, which the plaintiff asked this court to adopt the analysis in its decision-making, found that it's placed smack dab in the middle of procedural rules. How can you use depositions? Do you have to be 50 miles away from the court to be able to use the deposition in lieu of testimony? How do you serve papers? So it's a procedural rule sandwiched in a larger section of procedural rules. I'd like to also talk about the concern about the policy considerations of the notice provision. And the primary one was so that the government entity could investigate. I submit that if the legislature was concerned about those particular policy considerations, then it would have placed those policy considerations in the body of the Elliott Larson Civil Rights Act and the Persons with Disabilities Civil Rights Act. That's how the legislature expresses itself. It embeds policy considerations in the act. The legislature embedded in the act that the Elliott Larson Civil Rights Act is a remedial statute, so we really don't have to look any further than that. Additionally, if the legislature was concerned that 3 years was too long of a statute of limitations, people are going to forget things, we're going to delete complete databases of emails, they could have and would have shortened the statute of limitations. And how do we know that? We can just look to the Whistleblower Protection Act. The legislature has conditioned that act, has placed a 90-day statute of limitation on that act. So the
But Counsel, I
legislature.
have to ask a question, though. I mean, and I hear what you're saying, and both of you are doing an excellent job. But I guess the question I would go back to is, Brother Counsel did make, a compelling argument. Wayne is a very large institution. People do come and go. It's a very sizable employer. And the notice requirement is designed, according to Brother Counsel, or his argument being to basically, if you have a 3-year situation, it does make it harder for that entity to investigate, to find people, especially a large-scale entity like Wayne State. They have to track people down, and people do come and go, and department heads change, and provosts change. It's just typical university structure and nature. So, I mean, could you possibly address that from a public policy perspective or concern that, ultimately that 3-year period could be quite a long period of time, and the notice requirement was put in place to allow for the preservation of evidence, witness statements, et cetera?
Yes, I'd like to address that. There's no reason that Wayne State or any other governmental entity should be treated differently than any other employer when it comes to the application of the Elliott Larson Civil Rights Act or the Persons with Disabilities Civil Rights Act. And this court talked about that in Ansel Dua. That was a Whistleblower Protection Act claim, and I want to say it was Michigan State, but I'm blanking. The defendant argued that it should not be subject to a jury trial. And the court actually, there's a great quote, if I can turn to it quickly. Nothing in the act suggests that the state is not to be treated the same as a business. We find it significant that the legislature chose to subject the state to suit in circuit court. So it's just as a matter of fundamental fairness, Wayne State University shouldn't be treated any more favorably than General Motors just because they're large organizations with lots of turnover and lots of time passes and people forget. The legislature's already decided that 3 years is an appropriate time when it crafted the statute of limitations.
But how do the fact that the plaintiff may sue in either the Court of Claims or go to circuit court, why would we treat those two things differently?
Well, you would only treat them differently. So for example, let's say that this lawsuit, if we had requested reinstatement, Ms. Christie, the only thing she wanted to do was finish out her career. She worked for 43 years for Wayne State, and her life would not be complete unless she retired from Wayne State. So we file a claim asking for equitable relief and money damages. That claim belongs in the Court of Claims. We'd have to file a notice, we'd have to file the complaint there, but it's just dependent on the remedy sought. And that's just because statutes are written how they're written, and we didn't seek any equitable relief in this case. She kind of thought, if they don't want me after all this time, I'm going to move on. But the other policy consideration is that this is kind of a gotcha move. Nowhere in the statutes does it tell a plaintiff that they have to follow this additional step. Nowhere in the Michigan court rules, and I remember at oral argument before Judge Allen, he picked up the court rules and shook them and said, tell me where in this book I can find a requirement that she needs to file a notice of intent in the Court of Claims. It's not there. It's not fair. It's not contained in the language of the statutes, and this court should take the next step that it was poised to do in Progress 2 and find that it's an issue of compliance with the rules of the forum. Because, as we've discussed, immunity is not involved. There is no defense to immunity. It's not actually what the circuit court ruled on when it denied the motion for summary judgment. And as Justice Cavanagh said, can't just stand up and announce this is a defense based on immunity. It truly has to be based on immunity. And so that denial was not based on immunity and did not give the defendants an immediate right to appeal as of right. Unless there are any other questions.
Well, I addressed the gamesmanship that Brother Counsel brought up, that this could encourage or create gamesmanship. Explain, I mean, he made an argument on that basis, and I'm just wondering if you have a response to that.
My response is that good lawyers everywhere are going to try and interpret statutes and rules to benefit their client. I think it's the opposite of gamesmanship. I mean, the rules to follow when you file a suit that protects against discrimination are that you file with the circuit court. And frankly, I think it's gamesmanship to come in after the fact and say, oh, no, you're out of luck. You didn't file this piece of paper in a court that has no relation to where you want to be. That feels a lot like gamesmanship to me. Thank you.
Thank you very much. You are out of time. Sorry.
Good stuff.
The case will be submitted. Thank you.